Hi, welcome to another episode from our GDPR IQ Thought Leadership series. Here we'll be discussing how e-commerce businesses should manage personal data. The General Data Protection Regulation, or GDPR, became enforceable beginning May 25, 2018. The legislation places scrutiny on e-commerce websites for the way they collect the data of European citizens. Management consulting firm Oliver Wyman predicts that $6 billion in penalties will be levied against non-compliant companies in the first year of GDPR enforcement. The GDPR enables stronger data protection designed for the digital age, where it's possible to shop online from our mobiles and smartphones to order a pizza or book a taxi. E-commerce companies can collect this information to provide more accurate and targeted advertising. However, an individual can be identified by metadata related to their mobile device or desktop. The GDPR consists of a unified and clear set of rules to help individuals gain control of their personal information. Under the GDPR, e-commerce businesses processing EU citizens' personally identifiable information, or PII, personal or sensitive personal data need to have legitimate grounds for processing. This classification is tied to consent. Explicit consent is required to process sensitive personal data. The GDPR requires that consent be specific. This is a significant change for e-commerce organizations requiring clear affirmative action from individuals in order to be able to hold personal data in your electronic systems. The current practice of relying on a customer's silence, inactivity, or pre-ticked boxes is no longer sufficient. Privacy concerns surrounding cookies has been an issue for several years now. Recital 30 of the GDPR mentions cookies, an important update and requires robust opt-in consent. Personal data like IP addresses and other information collected by cookies is now no longer a corporate asset. Instead, it's owned by the data subject. To stay compliant with the GDPR, you will either have to abandon this practice or obtain consent from your customers. There are many systems that could be used to collect personal data. Each needs to be clearly identified and classified accordingly. Personal data should be kept only for as long as necessary. Simply put, if it's no longer needed, destroy it. The GDPR doesn't state a time frame for holding personal data. E-commerce sites will have to decide how long they hold on to data subjects' personal data, based on the purpose that data was processed for. Personal data that is no longer needed must be erased to reduce the risk of inaccuracy, excessiveness, irrelevance, out of date, or using such data in error. Storage limitation can also help you comply with other GDPR principles, specifically the data minimization and accuracy principles. It's clearly inefficient to store personal data that is not required, which can lead to avoidable costs on storage and security. Under the GDPR, site owners may have to respond to subject access requests. Larger and inaccurate datasets can make this much more challenging than it need be. E-commerce organizations should introduce a data retention policy and document standard retention periods for different categories of personal information. Retention policies must also be flexible enough to allow for early deletion of personal data if appropriate. Most e-commerce organizations store customer data in different places within their technology landscape, and their legacy systems do not support rapid deletion or anonymization. In the GDPR era, the future is about managing data, not just the storage and infrastructure on which it sits. Individuals from the EU freely provide their personal information to e-commerce sites. The recent Facebook Cambridge Analytica saga highlighted a case of invasion of privacy, facilitating data exploitation by some companies. Any breach must be reported to a local supervisory authority within 72 hours of the business being aware of the issue. Failure to notify can result in a penalty fine of up to 10 million euros, or 2% of global turnover. Negligent or intentional violation of GDPR can result in a fine of up to 20 million euros, or 4% of turnover. Northern American e-commerce businesses are not exempt from the GDPR if they market their products to EU markets. They ought to incorporate stringent data protection policies to avoid reputational damage and significant fines. Thanks for watching the GDPR for e-commerce video. Subscribe to our channel for more on how to tackle the EU GDPR, and feel free to watch more videos from our GDPR IQ series here. Don't forget to check out our website or follow our social channels. Thanks again, and looking forward to seeing you.